Hello, my name is Thomas Graham and I'm the Regulatory Manager at the Melbourne Space Program. Before I begin this presentation, I'd like to acknowledge the traditional custodians of the land on which I'm recording this presentation, the Bunurong people of the Kulin Nation, and pay respects to their elders past, present, and emerging. So today we're going to look at the international regulatory framework governing space debris mitigation and management, and we'll break that down into why space debris is a problem, how is it governed, what is wrong with the current international regulatory framework, and what potential solutions are there. And this is going to have to be a whistle-stop tour because I've only got 15 minutes and I can't do this topic justice. So to begin, the global space industry is growing rapidly, even in spite of the COVID-19 pandemic, with projections placing the value of the industry in the future by 2040 at about 1 to 3 trillion US dollars. So space activities are having a significant impact on Earth's orbital environment in the form of space debris being generated, and this will pose an increasingly greater risk not only to life but to equipment in orbit as well, and this is only going to get worse with mega constellations going up, cluttering the orbits further. The growth in space activities by all of humankind is testing the existing regulatory framework, because the original space treaties just simply didn't contemplate the types of activities and technologies involved in the space industry that eventually came along. So now a major response is needed from the international community to mitigate this threat and to preserve Earth's orbital environment for future generations. So in order to deal with space debris, we need to know what is it. And unfortunately there's no single definition of space debris out there, but a commonly accepted one comes from the IADC guidelines, which have been endorsed by the United Nations General Assembly. And this definition says that it consists of all man-made objects, including fragments and elements thereof, in Earth's orbit or re-entering the atmosphere that are non-functional. And that can be broken down into 4 different categories. I won't read them out, but they're on the slide there. And although these pieces of debris are usually small in size, they travel at a high velocity while in orbit. As such, they can pose a danger to equipment and astronauts, and so they have to be treated seriously. Now, looking at the current state of Earth's orbit, there's only about 3,600 satellites currently in orbit, but that number is increasing all the time rapidly. And there's approximately 28,210 debris objects being regularly tracked and catalogued. Again, that number is increasing all the time rapidly. I won't list the statistics on the screen because you can read them, but there are tens of thousands to millions of pieces of debris of varying sizes that are known, and only 6% of objects in orbit are actually operational spacecraft. Most is just pure machine debris. This debris growth is being driven by gradual accumulation and some specific collision and destruction events. Unfortunately, a tipping point may have already been reached, with current mitigation measures being insufficient and fragmentation possibly continuing to increase regardless of future activities. This is an increasingly pressing issue given more and more satellites are going up, such as the Starlink constellation and other constellations, and all of these objects in orbit mean that there's a greater chance of collisions occurring in orbit, and these objects possibly won't fall back into Earth's atmosphere and burn up within acceptable timeframes. This is going to cause all sorts of issues regarding collision avoidance maneuvers for operators, costing a lot of money, and the potential for property and personnel harm. So the worst case scenario when it comes to space debris is the possibility of Kessler Syndrome, wherein a runaway chain reaction of collisions creates a debris cloud around Earth, making access to orbit impossible and ruining any orbital infrastructure there, such as satellites. This would obviously cause immense economic and financial ruin and prevent the development of humanity, potentially for generations, in any way relating to space. Now, looking at the traditional regulatory framework governing space, we have the UN-based space treaties. The first was the Outer Space Treaty, the main one from 1967, which was couched in broad terms that provide limited guidance regarding space debris management. However, its breadth also serves to provide a flexible framework for further legal development, especially through the incorporation of international law principles under Article 3. Now, I don't have time to go into it, but a combination of Articles 1, 4, 6, and 9 may stipulate a minimum standard above which states are free to act regarding space debris and its management and mitigation. It may be possible that a state would fail to perform its treaty obligations if it knew of a risk regarding space debris and failed to mitigate against it. However, this obligation would not extend to remediation operations or active debris removal. It would only cover debris mitigation. Together, the aforementioned articles may amount to a requirement for state parties to implement and enforce national debris mitigation regulations and supervise space activities to ensure compliance, but this is by no means certain or universally accepted. Next, we have the Liability Convention from 1972, which again doesn't directly address space debris. It imposes international liability on states for space objects, which likely covers space debris under such a definition. It imposes a two-pronged system of liability, with absolute liability for harm on Earth, with fault-based liability for damage in outer space. Article 4 states treaty parties are jointly and severally liable, which could create an absolute mess when it comes to complex launch arrangements involving multiple states and more so complex collisions involving multiple chains of causation. Again, active debris removal or remediation is not contemplated at all by the Liability Convention, and so matters such as control, jurisdiction, liability during remediation activities are not directly addressed. Another relevant treaty for space debris is the Registration Convention from 1975, which created a dual registry regime for space objects launched into orbit. This consisted of a UN-based register that all launching states must submit certain information to, as well as states maintaining their own registers. The final space treaty relevant to space debris would be the Moon Agreement from 1979, which sought to build upon the Outer Space Treaty and introduced concepts such as the Common Heritage Principle, which mandated the rational management and equitable sharing of benefits derived from the use of outer space. This implied benefit sharing between developed and developing nations didn't sit well with certain state parties, and as such, very few parties actually signed on to the agreement, and it's largely unused and has little normative force nowadays. Since the space treaties in more recent years, more non-binding guidelines have become popular within the international community. The first significant set of these regarding space debris came about from the IADC in 2002. These were followed up by the UN guidelines in 2007, which were then endorsed by the General Assembly of the United Nations in 2010. This endorsement has made them the most significant set of guidelines and probably the most well-known, and they've been adopted widely. They contain 7 generalized voluntary principles that largely mirror the IADC guidelines but are less technical in nature, and they invite states and international organizations to refer to the IADC guidelines for guidance. Although they're non-binding, they're considered to have brought consensus regarding acceptable space activities in the absence of legally binding rules, and they've highlighted the importance of international cooperation and regulation, as well as voluntary implementation of mitigation frameworks by individual states. Many states around the world have their own practices and regulatory frameworks relating to regulating space debris. Many require space mission operators to provide information that would allow the governing state to comply with their treaty obligations, such as information required to be furnished under the Registration Convention. Many states also indirectly adopt international guidelines by considering compliance with them a factor under national licensing regimes, such as compliance in order to gain a launch license. Despite the lack of uniform domestic legislation between states, a degree of consistency can be observed in various policies and regulations. You can see some of this in the UN Compendium of Space Debris Mitigation Standards, which is available from the UN. This generally consistent state practice could give rise to international customary law that states give sufficient weight to international guidelines such that opinio juris could be deduced. As such, it could be taken that together, the non-binding instruments at the international level implicitly recognise, when combined with state practice and the approval of principles in the global legal framework, a state obligation to mitigate the generation of space debris, a failure of which would lead to international liability. Looking at issues with the current regulatory framework, there's a lack of funding and a general low risk to any individual satellite, and this creates adverse economic incentives for creating a robust regulatory system. It's also difficult to get states to commit to binding rules, as the topic of space debris tends to touch on issues of nuclear power sources and space weapons, which states don't want to limit their use of for national security and military purposes. There's also need to reform the basis of the international legal system for this, as the original documents just couldn't have foreseen the technological advancements that have occurred since their inception. Also, if soft law instruments can't be regarded as reflecting customary international law rules, their voluntary nature makes their legal force null, and so there's a need to avoid over-reliance on soft law measures in favour of developing legally binding norms such as new treaties. There now exists a development divide between nations with legacy space capabilities and those that are still getting into the space industry. This gap is causing a bit of a tension between the two groups because developing countries want debris mitigation and remediation to ensure they will actually have a navigable environment when they get to space. However, they don't want strict technical requirements on their missions, as it would make it harder for them to develop their programs. There's also been suggestions for the concept of common but differentiated responsibilities to be adopted when addressing issues of space debris at the international level. This may require advanced states to make their scientific and legal expertise available to countries with lower levels of space development in order to ensure appropriate debris mitigation practices. However, this is unlikely to occur because the technical information relating to space activities is often highly valuable. Further, it's likely justifiable that any potential hardship put on developing nations is okay, because the obligation would probably be recognised as a best effort obligation and would not require the complete elimination of any risks, only the best reasonable effort of the state's ability. If a state has the tech and resources to put objects into orbit, it probably also has the ability to plan and execute debris mitigation strategies, so this would not be an unbearable burden. There's an emerging need to develop a legal framework governing active debris removal or remediation in the future. Currently, it's almost completely unregulated, partly because ADR practices are not yet technologically or economically feasible, and the probability of collisions is not yet high enough to warrant worrying about it. However, this will likely change as technology advances and the orbital environment worsens. There are a few legal barriers to regulating ADR, such as the uncertainty on the definition of space debris or jurisdictional issues relating to physically capturing objects in space. Space technologies are developing quickly, and many of these technologies are being developed to mitigate and remediate debris. There are operations becoming more of a focus for many organizations, with technologies being developed such as nets, harpoons, electromagnetic tethers, drag sails, and these rapid developments in the space industry necessitate a revitalized approach to the regulation of space debris. We need a dynamic and adaptable system to govern the activities taking place within the sector as they evolve. Although reform is needed, the 5 original UN space treaties serve as an important constitutional foundation for the development of international space law. They don't need to be replaced, just built upon. In the legal sphere, there are many things we can do to improve the regulation here. We could have enhanced legal development and implementation of existing space treaties, with more states participating in the treaties, more detailed guidelines, ones which specifically cover remediation activities, more domestic regulation and enforcement. These are all needed to encourage cooperation and boost confidence in the existing international legal framework. We could also have enhanced treaty interpretation, making sure we recognise an implicit obligation to mitigate space debris as it currently stands in the Outer Space Treaty. We could import environmental law principles under Article 3 of the Outer Space Treaty and have principles such as intergenerational equity, sustainable development considerations and the like playing a part. And further, we could have a central authority guiding the international community and managing space debris and space traffic management in the future. A more traditional solution could be a new multilateral agreement which would explicitly address space debris. This would allow key issues such as the definition of space debris itself, as well as questions of jurisdiction, control, and remediation operations to all be properly addressed. This would create a new hard law document which would have more normative force in the international community than the existing soft law initiatives. The scope of any new agreement would have to be limited appropriately to entice state parties to join, because if it's too wide, they would feel restricted, and too narrow, the agreement wouldn't be effective. The difficulty of creating a new multilateral agreement can't be understated. The preference at the international level is for soft law instruments, and it's difficult to get states to commit to more binding agreements. You can see the Moon Agreement going down this path. That doesn't mean it's impossible, though. There is also an emerging business case for taking space debris seriously. As technologies make mitigation and remediation cheaper, and the chances of collisions in orbit increase, the economic incentives to take orbital debris management seriously and to take appropriate risk management steps will become increasingly prominent in the minds of mission operators. Further, regardless of the exact setup of the regulatory regime, the regulatory framework governing space debris must be well funded to succeed, regardless of its form. Now, various forms of fees have been proposed and they could be employed to generate funding, and such fees and taxes could be enforced at the domestic or international level before being used by any governing organisation. The centrality of insurance coverage to commercial space contract arrangements makes it an important tool in addressing space debris. Insurance providers could promote responsible behaviour by reducing premiums or fees to customers who reduce risks for themselves and others by demonstrating compliance with debris mitigation guidelines. In conclusion, the rapid growth of the global space industry necessitates action to deal with the growing space debris problem. The current international regulatory framework of space treaties and international guidelines is a good basis for the legal framework, but it needs reform to deal with space debris properly. Any obligation that can be read into the existing documents isn't strong enough or enforceable enough to be effective in actually combating the problem. Although there are barriers in the way of reform, various changes in the legal, diplomatic, and economic spheres are possible that could exert a positive influence on the health of Earth's orbital environment going forward. Thank you. I hope you enjoyed this presentation and found it informative.